Supreme Court orders Maine House to restore the vote of GOP lawmaker who ID'd trans teen athlete online. Supreme Court allows Trump to strip legal protections from 350,000 Venezuelans who risk deportation. Trump asks Supreme Court to allow him to end humanitarian parole for 500,000 people from 4 countries. Supreme Court allows Trump ban on transgender members of the military to take effect, for now. These are a handful of top U.S. Supreme Court headlines this month, May 2025. When the Constitution of the United States was written, our forefathers would never have even heard the term transgender, could not have imagined online communications and all of those implications, and a global economy meant no taxation without representation, touted in drawings of English tea being thrown into the Boston Harbor. You see, the Supreme Court was created by the Constitutional Convention of 1787 as the head of a federal court system, though it was not formally established until Congress passed the Judiciary Act in 1789. The opinions of the Supreme Court, including the dissenting opinions of individual justices, often have been considered epitomes of legal reasoning. But through these opinions, the court serves to clarify, refine, and test the philosophical ideals written into the Constitution and to translate them into working principles for a federal union under law. Beyond its specific contributions, this symbolic and pragmatic function may be regarded as the most significant role of the court. And size matters when it comes to the SCOTUS. Again, it is Congress that decides. It started with 7, was 8 justices for a while, but has been 9 since 1869. In the 1930s, President Franklin D. Roosevelt asked Congress to consider legislation that would have allowed the president to appoint an additional justice for each member of the court aged 70 years or older who refused to retire. This, quote, court packing plan was voted down. Now, today's Supreme Court is made up of 4 women, 2 of which are women of color, 5 men, 1 of which is a person of color, and the average age of the court is 64 years old. The oldest justice is 76, and that would be Clarence Thomas, the African-American confirmed to the bench in 1991, 33 years ago, despite the claims of sexual harassment against Anita Hill, an African-American colleague. Don't get me started on that media circus and divisive period in our history. That was way before the Me Too movement. So have we come very far since then? Well, that's why I do this podcast and why we are witnessing the 3rd wave of feminism, right? The work continues. Thank you for joining me for another episode of Her Stance. Let me introduce you to the first and second women appointed to the Supreme Court, respectively, Sandra Day O'Connor and Ruth Bader Ginsburg, also affectionately known as RBG. While relatively the same age, O'Connor, born in 1930, and Ginsburg in 1933, their backgrounds and paths to the Supreme Court of the United States, also known as SCOTUS, look very different. And yet, as sisters-in-law, they were great colleagues and supported each other and the causes for women's rights in equal share. So let's get into the deets. Sandra Day O'Connor was born into a family of Arizona ranchers. She was no stranger to hard work. She once said that all manpower was useful and every woman had a role to play. She attended Stanford University for both undergraduate and law school in the 1950s. She was one of a very few women seen on campus in those days. In contrast, RBG was born into a Jewish family in Brooklyn, New York. Her father was a Russian immigrant with no formal education except Hebrew school. She was witnessing a liberal revival movement in the big city, and young people were striving for self-fulfillment. Ginsburg graduated first in her class from Cornell University at 21. She married her husband the same year, and quickly they started their family. Then she and her husband went off to Harvard Law School. Harvard was not a welcoming environment for women. There were 4 other women in the program. The dean of the law school actually asked each of those women to justify themselves for taking up the place of a man that would otherwise have been there. She transferred to Columbia Law School and graduated from there. Both of these young women had amazing self-confidence and believed they were entitled to run the show and acted as if they were equal to the powerful men in their world. They both took offense when men told them they were inferior. Well, things did not get easier after law school for either of them. O'Connor was rejected by 40 law firms, not even being granted her interviews because she was a woman. In fact, one firm offered her a job as a secretary. She actually took a job for no pay. And then, when her husband became an attorney for the U.S. Army Judge Advocate General Corps, known as JAG, in Germany, she served as a civil attorney for the Army from 1954 to 57. In the 1960s and 70s, she then served as a state senator, and she was the first woman in the United States to occupy the majority leader position. And she had her first judgeship in Maricopa County's Superior Court in 1974. It was President Ronald Reagan, a Republican, who nominated her for the United States Supreme Court in 1981. Well, Ginsburg found it just as hard to navigate a career after law school. She had 3 strikes against her. She was a woman, a mother, and she was Jewish. So she took the teaching route. She took a job as a law professor at Rutgers Law School. Then she spent the 1970s with the American Civil Liberties Union Women's Rights Project, where she fought for gender equality in front of the Supreme Court. In 1980, she became a judge with the U.S. Circuit Court of Appeals. In the late 80s, she met both Hillary and President Bill Clinton at an event and impressed them both. And this led to her Supreme Court nomination by President Bill Clinton, a Democrat, in 1993. Regardless of which party your appointment came from, the Supreme Court was never meant to be political. And Sandra Day O'Connor and Ruth Bader Ginsburg were colleagues and often allies. They served together for 12 years. Now, they did take very different approaches. O'Connor was described as a very cheerful, energetic Westerner. She never complained, never asked for special treatment. She's quoted as saying, "Unfortunately, civility is hard to codify or legislate, but you know it when you see it. It is possible to disagree without being disagreeable." whereas Ginsburg was already an activist, having had years with the ACLU. She knew politics. If she didn't get what she wanted from the court, she appealed to Congress or used the media for public opinion. Her sentiment was, fight for things that you care about, but do it in a way that will lead others to join you. So, what did these women do for us? What is their legacy? O'Connor was often known as a swing justice. This means that she was in the ideological center, who may align with either her more conservative or more liberal colleagues to provide the key vote in closely divided cases. After her retirement, Justice Anthony Kennedy held that distinction. And today, Justice John Roberts appears to be the swing justice. In a series of rulings, O'Connor signaled a reluctance to support any decision that would deny women the right to choose a safe and legal abortion. Case in point, in 1989, because she sided with the more liberal view in Webster versus Reproductive Health Services, in which the court upheld a Missouri law that prohibited public employees from performing or assisting in abortions not necessary to save a woman's life, and that require doctors to determine the viability of a fetus if it was at least 20 weeks old. She reduced the court's opinion to a plurality. Through her stewardship in Planned Parenthood of Southeastern Pennsylvania versus Casey in 1992, the court reshaped its position on the right to abortion. The court's opinion, which O'Connor wrote with Justices Anthony Kennedy and David Souter, reaffirmed the constitutionality protected right to abortion established in Roe v. Wade in 1973. But also lowered the standard that legal restrictions on abortion must meet in order to pass constitutional muster. After Casey, such laws would be considered unconstitutional only if they created an undue burden on women seeking to obtain an abortion. Also, importantly, in 1982, O'Connor played a key role in Hogan versus Mississippi, which prohibited Mississippi from segregating the sexes in the state's public nursing schools. Now, Bader Ginsburg was also a force. Because of her work on U.S. versus Virginia Military Institute, June 1996, women are now accepted into the VMI. The case had originally been assigned to O'Connor, but she actually refused it because she knew that Ginsburg had labored as a Supreme Court lawyer at the ACLU in the 1970s to get the court to call women equal. O'Connor felt it was Ginsburg's case. In her opinion, Ginsburg actually cited the 1982 Hogan versus Mississippi opinion by O'Connor. These two women opined on 88 cases over their 12 years serving together, on topics ranging from criminal procedure to civil rights to judicial power. Not all were earth-shattering, but all important to keep our Constitution relevant and tested for the times. O'Connor thought that social change should occur slowly, so she limited the scope of her opinions to the facts of the case. She wasn't threatening to the establishment, while also almost always deciding in favor of the female plaintiff. Ginsburg saw her America as an expanding country of inclusiveness. She could see the Constitution as a living document and a living manifestation of that American experiment. According to the book entitled Sisters-in-Law by Linda Hirschman, after O'Connor retired, the conservative court turned their backs on women's rights and Ginsburg became the icon of resistance to the backlash with her fiery dissents. Sandra Day O'Connor retired in 2006, and she died in 2023. Ruth Bader Ginsburg never left the bench. She stayed until her death in 2021, never giving up the fight. The fights must continue, not just for women's rights, but for human rights, and not just for our country's constitutional rights, but for global compassion, global equity, global dignity, and even for online civility. There is a current case being considered. It's TikTok Inc. versus Garland, 2025. It notes that this case, quote, involves new technologies with transformative capabilities, unquote. And it says that, as Justice Frankfurter advised 80 years ago in considering the application of established legal rules to the totally new problems raised by the airplane and radio, we should take care not to embarrass the future. And they cited Northwest Airlines, Inc. versus Minnesota, 1944. Never before has RBG's idea of a living constitution been more tested. Well, you've made it to the Her Stance Challenge, and maybe you can guess it. Get to know our Constitution. I'm going to provide the resource for you in the show notes. And why should we do this? Civics knowledge surveys conducted by the Annenberg Public Policy Center show that Americans lack a basic understanding of the Constitution and how our system of governance works. So they have provided an interactive guide for us to learn all about it. At www.annenbergclassroom.org/constitution, here is a site providing the original text and an explanation of the meaning of each article and amendment. Visit this site and learn about one of our nation's founding documents and the establishment of the federal government. You'll also find landmark Supreme Court cases on this site. By clicking on the link, Supreme Court Cases, you'll see right at the top a conversation on the Constitution with Justices Stephen Breyer, Anthony Kennedy, and Sandra Day O'Connor, Brown versus Board of Education, the landmark case that ended racial segregation in schools. My hope is that with all of this new information at your fingertips, you will have a new perspective to bring to the nation's headlines and social media's conversations. May the voices of Sandra Day O'Connor and Ruth Bader Ginsburg ring loud and clear for you as we carry on the fight they started. Thanks for listening to Her Stance. Please share a comment, like, and share this episode, as all of the episodes. Check out Linda Hirschman's biography of these two women, sisters-in-law. This program has been written, hosted, and produced by me, Sandra Cable. Until next time, thanks for taking Her Stance.